Welcome to the Estates Made Simple podcast with Jenna Carvello and Gordon Vanderleek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Hello, everyone. We are excited to be back and chatting with you today about a topic that's very relevant for a lot of people. Gord, nice to see you again. I know it's been a few weeks since we met, but it's always fun to chat about these exciting topics.
Yeah, exactly. And it's a bit of a break from the recording, but always delightful to podcast together and to have a conversation that we get to share with our followers. So thank you all for tuning in. And I think I like this topic, which is about what an executor should ask the person who made the appointment. We refer to that sometimes as the testator, when they've passed away, or that's sometimes how it's referred to in a will. So maybe introduce that topic and some initial thoughts that you have on that, Jenna.
Yes, definitely. So as I mentioned, many people have to go through this process of choosing an executor, writing down who the executor is in their own will. But there is a little bit of a missing component of asking the executor if they're willing to act and having the opportunity for the executor to say, yes, feel free to appoint me. Or no, I don't want to act, because, it is a huge task, and having that conversation up front is much more proactive and efficient than having the executor be surprised when the testator passes away. So we want to talk about today about what the executor, the proposed executor, should ask the testator before agreeing to that appointment. So from a number of standpoints, I thought we'd start with some practical standpoints. Gordon, I know that you've acted as an executor for some individuals and have recommended other executors, but from a practical standpoint, what would you suggest the proposed executor to ask before saying yes?
Yeah, which is hopefully, as you say, hopefully that conversation happens, right? And if I'm talking to somebody who's drafting the will, I always say it's fine if you give me the names of people you want me to put in the will, but have you had a conversation with them? Because just because you're nominated doesn't mean you have to say yes, right? You still have to consent to this role, but I think it's fair to say that the role of the executor is a significant one. So there should be a dialogue. I guess that's the theme here, is there should be a dialogue between the parties so that it is done willingly and with some foreknowledge. And I think if you're saying what questions should, like, I've been approached, what do I even say? How do I respond? Mm-hmm. I think on the practical matters, one good question would be, well, where are the documents? Where's the will? I have it. It happens more often than you might think that somebody says, oh, so-and-so passed away. I'm the executor and I'm rummaging around trying to find the will. And I can't start my process of going through the probate until we find the will, or if we can't find the will, we have to make an exhaustive search to be able to verify that, in fact, the will cannot be found. If there's a will, maybe we have a copy of it, but we can't find the original, then we have to detail all that in the application to the court. So just a practical matter of where's the will. It's going to come up fairly quickly, because if you're making arrangements with a funeral home for the disposition of the body, or the celebration of life, the funeral, all those arrangements, at the very beginning, the funeral home's going to say, well, show me that you have the authority, right? This is the document. I mean, obviously, it takes a while to go through the probate process, but in that context, you want to know where it is, right? Oftentimes, we'll give a bunch of notarial copies right in the beginning, just so, because we know they have to hand it around to a whole pile of people. And this is the document, and generally, especially in those initial stages, people will accept that as the right document. I think you want to know a little bit about the person's estate. Like, what is the job description that you are potentially thinking of signing up for? If and that's different. It's not like every estate is different, and it could be comprised of sort of just knowing what are the assets out there. And there can be very simple estates, or there can be very complex estates, and everything in between. If somebody is running an active business and you say you're the executor, well, guess what? You're going to have to continue that business and then potentially sell the business or deal with other shareholders of the business on a buy sell. That's very significantly different than, okay, it's a senior person who's 85 years old and everything's in GICs at the bank. Right? Those are two very different job descriptions. Getting a sense of what assets are in the estate will help you determine, well, how much time is this actually going to take, and do I have that time? Relating to that, how tidy is the estate?
Yes.
If this is an estate where, oh, the person hasn't filed taxes for the last 10 years, well, that's a significant amount of work. Like, how are you going to do it? You got to go get all the tax slips and you got to put it together. That's going to be a big job. So you might say, well, are your taxes up to date? That might be a good impetus for the person. You say, well, I'll accept it as long as you tell me that everything's tidied. If there's a safety deposit box, how are you going to get in there? You mentioned that, and I am on a select basis agreed to appointments as an executor. And one more recently, we knew there was a safety deposit box, but we couldn't find the key. The person did not give it to the family member who we thought had it, but she couldn't either, it went missing or she couldn't find it. So we had to get into the safety deposit box. So now you got to hire somebody. The locksmith came there and drilled it out, and extra costs and a bunch of trips back and forth. Ironically, it turned out there was nothing in the safety deposit box.
No.
I always thought that's sort of the fun part. Like there's some mysterious item in the safety, but it was blank. It was so I wanted the rare stamp collection or the gold bars or something interesting. In any event, if you have places, if important items that are relating to the distribution that are relevant to the distribution of assets in the estate are mentioned in the will, like, do you know where they are? Do you know where if you got original share certificates in the safety deposit box, are you going to be able to get those? Again, even knowing where the will is important on that. And I, just having that list of assets. I don't think you necessarily need to know, how exact bank balance is, because of course that's going to change over time. But generally speaking, saying, well, where is your stuff? Like, how many bank accounts do you have? Those are things that I think are helpful to know, or at least say, make the list, agree on where it's going to be located, so you know where to go find it when you have to start your work. And then you have all the information. So you can ask, saying, can you at least on an annual basis make that list and keep it current? So when I go in, I know where to find it. And that, of course, what we see, I guess my last thought or last couple thoughts here would be even knowing where their passwords are. Like, are you going to be able to go into Facebook and memorialize their account? Or what do they want? You want to download their pictures to give to the family. If they have cryptocurrency, that'd probably be a good thing to know, right? And where's that secret key so you can access that? Like all that kind of practical stuff. So if you think through this, what am I going to need to administer and deal with the assets of the estate? I think some obvious questions will come to mind. So have a conversation about that so you're well prepared. And I think the conversation with the person who's requesting you be executor, we've referred to that as the testator, you can say, well, if we have, this seems a bit invasive, I'm asking all these questions, but ultimately this is going to save you money because there's less time I'm going to spend, so that will reduce my bill to the estate. So it's good to have those conversations ahead of time, and I think those are fair questions. And I would ask for, like, okay, what do you want at the funeral? Like, do you want a funeral? Do you not want a funeral? Do you want to be cremated? Do you want to be buried? What do we do with those things? There's lots of choices that, if it involves other family members, would have some opinions about that. So to the extent there's conversations and where stuff are, that's helpful. If there's a list, if there's a memorandum of instructions about what to do with personal belongings, well, where is that? It doesn't do much good to say, well, I think there was one, I just can't find it. Well, that's not a very good way to start. So I think gathering all those important documents, knowing where things are in safekeeping, what the final instructions are, and having those lists of assets would be those immediate practical matters, because this is all the information you're going to have to give to the lawyer to just go through probate, right? Plus other professionals would be involved with that.
Well, I like the way you put it. You want to know what type of job you're signing up for, because a disorganized estate is very difficult to manage versus a well-organized estate. And even with respect to funeral instructions, it brings me back to when I was an executor and I met with a testator before he passed, and we wrote out his obituary together because he had very specific wishes of what he wanted to tell the world. And that was a powerful moment for both of us to ensure that his wishes were followed through. So, you spoke a lot about practical matters, and we also want to highlight today more of the intangible or the softer issues around the beneficiaries. So if the beneficiaries, this is what I would ask as an executor, if the beneficiaries get along and if they will respect the appointment that that the testator is making. So I think, in a state that has beneficiaries that are aware of the appointment and beneficiaries that tend to get along quite well, the estate will be much more smooth. But a surprise appointment and maybe some disputes within the estate could be becoming quite hairy, and maybe the executor doesn't want to act in that case. Particularly when you have blended families, I'll pick on blended families for a moment. There can be some different types of relationships that harbor some feelings that come forward in the estate administration process, and as the executor has to manage all of those types of nuanced conversations, it is time consuming, stressful, and also you have the emotional burden of navigating the loss of the loved one as well.
And on that point, even as you're talking, I'm reflecting on the fact a really good question would be, well, is it me alone or am I working with somebody else? I mean, a really basic thing like that. You talk about people getting along. If it's a joint appointment, I think you want to have some input on, well, do you want to work with this person? Or how are disputes going to be resolved? Like those would be important considerations to say, well, because if you go, well, I'm not working with that person, well, that's good to ask that question ahead of time, because you may say no, because if I'm going to do it, I want to do it alone. I'm not saying that's every situation, but that's an example where you could have that conversation and influence the decision about how the will is drafted in terms of whether it's a joint appointment or not, or maybe more specifics. But yeah, just that's a fair consideration. I don't know that if I know this is going to be highly contentious, I'd probably be reluctant to get in the middle of it, right? Those are often, you say, well, go talk to the trust company, right? They'll handle those things. But that's fair. You go, hey, I don't mind being the executor, but I don't want to have to be going to court and, potentially getting sued, and now there's liability. And what if I'm left holding the bag with regard to some of these costs, and that just, I'm going to lose sleep at night, and I just don't want to do it. I'm not ready for that level of stress, I think, is another way of saying, are people getting along, and what's the contention level in the estate would determine, are you able to handle that, right? Is that okay, right? And it's fair to say that's too complicated. I think you need to, I'd rather not do it.
Yeah. Well, and as you mentioned, working with someone who has different viewpoints and different ways of doing business is a challenge. If you have a joint appointment, both executors typically have to make decisions together. So if they disagree on every single decision, that's also going to delay the estate administration and cause additional expense that may be not necessary. And so, that's more of the softer type of conversation to have with family members. And then, the third component, of course, is the complexity of the estate as an executor. Are they knowledgeable and skilled enough to handle that? And I know, Gord, you have some good comments on that.
Yeah, and I think that's definitely a relevant consideration, right? I mean, that would be kind of to my opening comments. Is this the estate with everything's in a GIC at one bank versus there's a small business and got interest in a limited partnership and invested in an oil well, and there's mineral rights, and there's all these agreements, and they co-own property in the Shuswap with a couple of buddies. Like, okay, that's highly complicated. Another, so that's just gonna, it's a relevant factor for saying yes, I think, is what we're saying, is the overall complexity. And I think another part of that, the complexity, is to look at, are there any potential claims that are coming up? And it really, like that, if you go, this is going to be an estate fraught with litigation, and you can kind of see that. I mean, I wouldn't go so far as to say that if you see that situation, you should say no. Maybe it's okay. I think it's, you want to go in with your eyes open, and kind of it's informed consent, if you will, right? Like know that if you're going to say yes, know what you're getting yourself into, and then you can think through, do I want to handle that, or do I not? If you know it's a blended family situation and you're the family friend because you're being asked, because he doesn't want to appoint his, let's say it's a guy and he's appointed his choice is his second wife or his adult children. And you're going to go, they don't get along. So, oh, Gord, if you're my friend, can you do it? And I'm going, okay, this is, if I look at the distribution plan, there's going to be all sorts of fighting, or the spouse is probably going to make a claim and the kids don't get along, and they're not going to be happy with his instructions. And I might say yes to that, but I'm going to know, okay, I'm going to be ready. There may be a couple of years worth of litigation on that, and I got to be ready for that. And am I ready for that? And do I want to say yes to that? And in that context, I think you also want to know who are the other people you would want to work with. I think a list of advisors for those more complex estate would be a relevant question to ask, to say, well, well, give me that list. Like, who's your accountant? Who's the financial planner? All those things is sort of tied to, well, what are your assets? What is out there, right? Because you're going to have to turn to these people for advice or potentially go get somebody else who could help you. So yeah, just having a conversation. If somebody's running a business, getting to know the CFO or, who's in charge of the finances. What does that look like? Is the company in the middle of litigation that you would end up having to deal with? All those sorts of things you definitely want to look at. So judge the overall complexity of the estate. It doesn't happen often, but I think one resource, could be other professionals in the field. So I guess we could look to each other to say, I'm sure those are conversations you've had in the past, and I know I have had as well. Not often, but sometimes. And I always, I think they're good conversations to have where somebody says, well, what do you think? Should I do this? Just looking, again, maybe that relates to the complexity, just understanding the probate process and what's going to be involved and what would be, what does it look like from a legal perspective? So even just talking to your lawyer or a lawyer or the person's lawyer and say, hey, what do you see happening? Educate yourself, right? Go back and listen to prior episodes on our podcast to say what's involved in becoming in serving in this role, and educate yourself not only of the specific situations, but the general requirements of what's required for these roles would be great questions to ask. And I guess a final thought would be candid with regard to the amount of time or a time length for that consent. I think it's fair to say, hey, I could see myself doing this for the next 5 years, but after that, I plan on being a snowbird in Arizona and I won't have the time. And then I want you to pick somebody else. Right. And then make a note of it. Keep a list of where you've said yes, because it's easy to forget these things. And that way you can go back to somebody and say, hey, have you picked somebody else? Because the 5 years is up. I said I'm only doing this for 5 years, but I no longer have the time, because I think people forget they said yes. And it's good to check in on those things. So keep a list and just review that on a regular basis to make sure that if you said yes before, that it still makes sense for saying yes.
Well, and hopefully the individual hasn't been appointed in several estates that all come in at the same time, because that obviously would be an additional amount of work. So
that's kind of the equivalent, Jenna, of saying you've got to be careful about showing how good a mom you are to all your friends, because they're all going to want to appoint you, or your siblings. They're going to want to appoint you and your husband as guardians. And suddenly if they all pass away, now you've got a real big family like that. It'd be like, oh, yikes. Right. So good to keep track of these things of where you said yes.
Yeah, because you can end up with a lot of kids, right?
Yeah. Or a lot of estate appointments at once. Right. And that gets to the capacity issue. So the only way to evaluate that is start by keeping a list. And then now you have a list where maybe more frequently you're going back to the person and saying, what about that, right? And I think it's good to have those conversations. If you said yes for a parent, well, sit down and say, hey, have your views changed? Has there been any changes? And are you still willing to do it? And just, that's more likely that you're going to be in a situation where you have to renounce, or you're feeling bad for having renounced because you just can't do it. And you go, oh, shoot, I should have had a conversation with the person ahead of time, right? To tell them so they had an opportunity to pick somebody else.
Yes. And so after you've, done all your questioning, researched all of the tasks that are involved with being an executor, and you feel like you could do it, but you just don't want to do it, you can say no and tell the testator ahead of time so that they have an opportunity to find somebody else. These conversations are so important and are not as common as you may think. So if you just don't want to do it, say no and move on. And I think that's a good final comment, is you got to trust your instinct and your
Absolutely.
own abilities.
And make an informed, I think the theme of this podcast would be make an informed choice, right? So get the answers to the good questions, or and hopefully this podcast gives you some ideas of the types of questions to ask, but reach out to other advisors going, if, in this situation, what should I ask or what should I do? So I think it's appropriate to get help and to take the appointment, seriously, because if you're going to say yes, then you want to go through with it, right? Because the person's expecting you to. So in fairness to them, I think if, you want to be clear, make a clear decision and be decisive, and then, and then you have all the tools necessary. It's going to be as smooth as it possibly can if you do that preparatory work.
Yeah, absolutely.
Yeah.
Well, to all of our listeners, thank you so much for tuning in. We, as you can tell, we love these types of topics, and we hope you do too. If you have any ideas for future topics, feel free to email or connect with us on YouTube or LinkedIn. It was a pleasure speaking with you, Gord, and we look forward to our next conversation.